I remember we had a conversation, and I don't know if you can touch on it now, but we knew now, and what's happening was that as people were re-entering the country, some people were being stopped. I don't want to get too into the grain, but
Yeah,
you said to me the law is being tested right now, that different
yeah,
laws
yeah,
are being applied in different cases,
yeah.
um, for the sake of almost rewriting the law. And the limited amount that I know about the law is there a precedent? And once a precedent is established, it almost changes the application of the intent. So I don't know if you remember that conversation, but could you educate me a little bit more, or educate our audience on, what were you thinking when you were saying that to me?
Sure. So, if you look at the history of constitutional law, everything kind of builds over time. One case kind of builds on another, and the cases are kind of informed by what goes on at that time, like historically, or just as whatever is going on now is
Hmm.
informing our case law, and 20 years from now, that's what is going to be the law. So, for example, I think right now, there are certain powers that Congress has, and there are certain laws that are being tapped into and used in a way that were not the original intent of Congress. So, one example is the Alien Enemies Act that is being used right now. And this originally came from the Alien and Sedition Acts of 1798, which were
Wow.
repealed. And the only thing that remained was this one act, the Alien Enemies Act. And the last time that this was used was by President Roosevelt during World War II. What this act says is that it gives the president wartime power to detain, restrain, or remove or impose limitations on people from certain countries that we perceive to be a threat to the safety and welfare of the United States. So,
Oh.
key thing here is warfare, right? During a critical moment in time. And this was almost, while this was justified, right, and used by President Roosevelt during World War II, because there was a wartime going over there, it was also misused because this was used explicitly against people from Italy, Japan, um, and Germany. And then it was also used to put a lot of Japanese people in concentration camps. And this is a part of our U.S. history that's not that great. And so now we see this law being used again to justify the detention of people where there is no basis to detain them. And one example of this is, of course, the Mahmoud Khalil case, right? This is something that the Secretary of State stated as the basis for the detention. But Rod, this is something that is supposed to be used in times of warfare, and it's not really justified in this case. So we see the government currently taking this law and expanding its intent
Mm.
and the definition and making it broader than what it was intended to be used for. And this is just one example of the law. Another thing that's very important right now, I mean, I'll let you.
No, 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 no. I'm amazed at this. But
Yeah,
okay, nothing. I
yeah,
want to hear
yeah,
more.
yeah. Another thing that's very important and that's related to immigration law is the plenary power doctrine. So this goes back to giving the government broad, like almost unchecked authority over a specific area of law without judicial review. And there's a bit of a history that's tied to this, but the US government is currently using this during this time right now. And you're seeing it in several of the lawsuits that are going on, where they are saying that it is the government and executive, they get to decide what is going to be the law, and other branches of the government should not have an input into this. So we're seeing the government really utilizing certain laws that are broad and using that to implement certain policies that are not favorable towards people who are here without status, and also overriding certain protections that were given to to immigrants who are here without status. So, for example, the U.S. Constitution states that both citizens and non-citizens have the right to due process. And in this case called Yamada v. Fisher in 1903, the Supreme Court stated that even non citizens facing deportation are entitled to some level of due process. We see now here that there are various people that are being, that were deported and removed from the United States without due process. And Rod, this is a fundamental right that citizens and non citizens have. There were various case laws, one after the other, that cemented this right. And for the government to just go and kind of take these actions, not respecting the law and constitutional rights that non citizens have, raises questions as to the validity of the Constitution and the power of the Constitution, right?
Yeah.